Welcome to the Republican Professor. I'm your host, Dr. Lucas J. Mather. Welcome. It is 19 November 2025 years after Jesus. It's a Wednesday, and it's a sunny day in SoCal. It's mild. It's definitely, I think, long pants, long sleeve shirt kind of a day, but it's partly cloudy, mostly not cloudy. And when you're in the sun, feels great. You're getting your vitamin C or vitamin D or whatever it is. I don't even know. Today, we are in the 10th Circuit Court of Appeals decision against New Mexico's 7-day waiting period, arbitrary and capricious waiting period for firearms transfers. You can get there by simply going to the 10th Circuit website. It was filed 19 August 2025 years after Jesus, and it's styled as Ortega versus Grisham. We have a reading from Psalm 85 at the end of the episode and Streams in the Desert, January 19th. I thought I would tell you a little bit about myself before we get to finishing this. This is the third episode on this case, Ortega versus Grisham, on the 7-day waiting period, getting hammered by the court, especially the Republicans on the court. Excuse me. Sorry, I'm going to mute my audio so I can cough. Yeah, so the Republicans on the 10th Circuit had the right answer. Um, but let me tell you a little bit about my experience. I don't want to tell you too much because we're pretty private as Second Amendment people. We don't like to brag or we don't like to. I'm just telling you this just because I want you to know a little bit about where I'm coming from. I am reading Streams in the Desert. I'm reading the Psalms. We're talking about the Second Amendment and self-defense. And you probably notice I'm coming at this from a Christian point of view. I am a military veteran. I am one of those guys that went into the military right out of high school. And it's not because I couldn't get into college. Okay. I did it because I really believed in it. And I grew up in Jefferson County Public Schools in a little town called Littleton, Colorado, which is in the 10th Circuit. So the reason I'm pointing this out is because even though I live in the Ninth Circuit in California right now, when I read this stuff in the 10th Circuit, which is where Gorsuch came from, this stuff hits home for me as well because this, New Mexico, Colorado, the 10th Circuit mountain states are where I am from. I grew up in Colorado. Let me just tell you a little bit more about myself. Although I went to Chatfield High School and graduated as a rival of Columbine High School, when I was a kid, I played Columbine sports. I was a Columbine destroyer, which is the name of our soccer team. We were undefeated. The colors are green and the same colors as Columbine. Actually, Columbine High School maybe has different colors now, I guess, but um, firearms were part of the community. It wasn't really that controversial, I don't think. I mean, I would read the Rocky Mountain News, I would read the Denver Post, because I was a paper boy. And when you're a paper boy, you read your product, and it's not like drug dealers where you're not supposed to sample your own product. I actually read that stuff when I was in high school. And it inspired me to be an editorial writer for my high school newspaper, the Chatfield Charter, which I did for 3 years, sophomore, junior, and senior year. I wrote editorials. One of the first editorials I wrote, it was the second one I wrote of at least a dozen, at least, was on gun control. And that would have been in 1990, it was published. And I remember I was referring to the Stockton school murders that had happened in California, which was part of what led in California in the minds of the elected officials and the population, unfortunately Republican governor at the time, uh, to ban so-called assault weapons and also have their critical eye on so-called large capacity magazines. And there's a case pending before the U.S. Supreme Court right now, the Duncan case. Well, it's not pending. It's the cert petition is pending, I should say. They're going to consider it this Friday. They have it under active consideration for this Friday on the 21st of November, 2025. So we've been following that case for a long time. We had the lawyer that won the case. We had him on the podcast, Chuck Michelle, a couple times. We've talked about the trial opinion in that case. We've talked about waiting periods. We've talked about all sorts of different aspects of the Second Amendment. Well, for me, going back, it goes back to my childhood because when I was in seventh grade, I went through the hunter safety course in Lakewood. I forget what it's called, Foothills. I think it was called Foothills Shooting Center. I can't remember. I really wish I had their business card as just that would be a really cool little souvenir to have from that time period. I don't think it exists anymore, but that was a normal place where you went to get your hunter safety certificate. And I believe it was the first indoor shooting range I'd ever seen, I'd ever been in before. All the shooting that I had done up until seventh grade was outside, either at an outdoor range or out in the mountains. Typically it was in the mountains. I remember thinking it was a waste of money to go to a shooting range. That's how I thought when I was a kid. So I got my hunter safety certificate, and I can't remember if that was before or after my first firearm. It would have been in the same year as I got my first firearm, which when I got my first firearm, I was in seventh grade. I got it for Christmas, and that started a firearms training and um, acquisition of knowledge, acquisition of skill that continued into the military. And Columbine, the school murders happened when I was in the military. Um, and I did have a sister that age um, at that time. She was not in the school, but she was home. But I did think about when the issue of gun control comes back up, it comes back over and over again. And I remember people thinking I think people told me, you shouldn't worry about gun control. Don't keep harping on gun control. It's not something you really need to learn about. It's going to go away. The issue is going to go away. We're all going to end up agreeing. And I remember thinking to myself, no, it's going to keep coming back. It's a basic issue that people have a problem with. And I don't think there's going to be agreement on this. Now, I'm hoping that some issues, some pretty foundational issues, get settled by the Supreme Court for several decades. So we don't have to keep relitigating every little thing. And obviously, I think I'm correct in my views about it. So I'd like to see those views prevail. And I also come at this from a Christian perspective, which means I believe that the human heart is hopelessly sinful and without hope, without God. Now, as you probably are aware, if I would join the military right out of high school, I engage in hypothetical thinking. If I taught philosophy for 20 years, which is what I did, if I went and did all the work necessary to get a PhD in public law for 11 years, just so I could focus on the Second Amendment and make sure I knew what I was talking about, you probably think I'm pretty serious about this stuff, and I am. I'm very serious about it. The first legal gun that I bought, which they're all legal as far as I know, um, but the first gun I bought was was at a gun show in Texas. It did make it sound, I guess it did make it kind of sound like I had some experience with illegal, but I don't have any experience with illegal firearm sales or anything like that. But what I mean is, I guess I should say, the first acquisition of a firearm that was not a gift when I was a kid. Okay, so I had some gifts as a kid, but the first one that I bought, like my own lawful status, is what I meant to say, as a person with my own money, and it's not a gift. It's not for Christmas. It's not under adult supervision. I'm a man, right? I was in the military and I was active duty. I was stationed in, at the time, Texas at Goodfellow Air Force Base, going through training for special operations, and intelligence type training. And there was a gun show. My uncle was an FFL at the time, and I still have the receipt. I still have the receipt. It was 1995, and I bought a what now would be called a high capacity magazine, but it was they call it a large capacity magazine, but I don't remember it being called that. I just bought one, and it was with an SKS, which was a Chinese, um, I think it would be called a military style rifle. It was a military rifle. It was military surplus. So I think the opponents of these kinds of things, there was a lot of Eastern Bloc country stuff like coming out of like the Iron Curtain, and then China was getting rid of a bunch of its stuff and dumping it on our market, and you could buy it for, I can't remember what the price was. I have the receipt. I could look, but it was really cheap. It was really cheap. So I bought one 30 round magazine at the time, and then I bought the SKS. And I remember thinking to myself, wow, I just bought a rifle, a military rifle, and somebody said it was an assault rifle. And so we have these labels or whatever, but the rifle was not something that I could have on base, so I had to make other arrangements for storage and safekeeping and all that stuff. But that was the first one. I was 20 years old. And that that has continued. I mean, I was trained by Navy SEALs. I did the, expert pistol qualification course. Did that on Fort Ord when I was stationed in Monterey, California. The SEALs, there was lots of special warfare people in all the branches, a lot of Army special warfare on Presidio of Monterey. Navy SEALs. There was a Navy SEAL Team 6 guy that was in charge of our PT. That was really fun. I wish I remembered that guy's name. I remember he was an E6, and I remember he could do basically whatever he wanted. I remember thinking, God, that looks like the guy looks like he has a nice life. Just sitting down there in the gym with his feet up, his boots up, comes in whenever he wants. But um, I'm trying to say that I've thought about this for a long time. I spent 6 years in seminary, and I've thought about this for a long time from a Christian perspective. And so when I go through these court decisions and lead you through the reasoning, the rationale, it's because I really believe in it. It's not that I think that it's to replace critical thinking skills or anything like that. There's this slogan going around that true education teaches you not what to think, but how to think. Okay, but that's saying that is an example of what to think, not how. So you got at least one example of what to think. It is okay to teach people what to think because you can't teach them how without what. There's got to be some what's. And this is one of those things where I think it's really important to teach people, or like if you're going to teach them how to handle a firearm, for example, you got to teach them the what's, like what not to do, what to do, and those are what's. On the constitutional law angle, on that level of things, where you're getting into the depth of the material, the depth of the natural law, the depth of the public law, on the right to self-defense, the theological underpinnings, the way to understand it from a Christian perspective, given that we are created in the image of God, bearers of rights and responsibilities toward each other, and desperately wicked and sinful. And uh, there's a law against murder, and it's helpful to think hypothetically. Well, you know, like when I joined the military not because I thought we would be attacked, but because I thought about the hypotheticals. What if we are attacked? We got to be ready. And you that means people have to volunteer and people have to be ready. That was my thought process as a kid. And uh even when I think about the hypotheticals around Columbine, I remember thinking that Columbine, because Columbine had the library that everybody went to, the public library, a Columbine Public Library just was the high school. So when we went to the public library, it was the high school library. And then they made the separate public library called also Columbine Public Library. So now there's two Columbine libraries. One is specifically the public one, and one's the high school. But originally, the two were the same in the high school. So we were in that high school quite a bit. I did sports, so I was in the high school quite a bit whenever we would compete with them. I grew up in Columbine sports. And I remember thinking hypothetically that the school is not a prison. It may be a sensitive place in somebody's mind, but it's not the same thing as a prison. It's not designed to keep people out. And in fact, it used to be where the doors were unlocked. You could go any time of day and go through the doors, any of the doors. And that's how it was at Chatfield too. I remember being late for school and I didn't want to go through the front door. I went through the side door and the door was unlocked. And you could do that back in my day. Back in my day. And back in my day means that was when I could go buy shotgun shells at Walmart after school and go up to the mountains and go shooting. I don't think I ever had a firearm in my car on the school property because I didn't wouldn't want to get the firearm stolen. And not like there was a lot of theft, but my door didn't lock properly, and I just didn't want to treat my firearms that way, like sticking them in the back of the seat. I just didn't want to. I have more pride in my firearms than that. But that's something that we could have done, and we could go buy a box of 22s at Gart Brothers. I don't remember ever having a problem with that. Like, I don't remember anybody giving me a problem about that. Um, but you think hypothetically, you think a school is not the same thing as a fortress. Anybody can just walk in there and commit murder. Gradually, there's been a hardening of those targets, uh, because I think in some measure, the strength of this anti-gun control arguments has forced that to be the option, which I thought was probably, not a bad option to begin with. There's a lot of lack of ability to think hypothetically about the Second Amendment, about Christianity as and it relates to that. Think about Charlie Kirk. Charlie Kirk was assassinated. He didn't have a chance to fight back, but what if things had played out differently and he did have a chance to fight back? What would have been the appropriate response? He had a security team. They were all armed. Law enforcement was present. They're armed. And they're armed for the same reason that ordinary citizens are, for self-defense. So you go back to the self-defense issue because of the issue of sinfulness and the law against murder and enforcing that law against murder. There's 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 the basis for the Second Amendment, the law against murder. You have a right not to be murdered. So that's why that I mean that's what we're talking about when we talk about the New Mexico legislature banning immediate possession of something that is a fundamental right, not only in the natural law, but ensconced in the public law and the positive law as articulated by the Supreme Court. Now, we've gone all the way through page 23, most of the way through 23. So we're going to continue with our presentation of the Republican majority in the 10th Circuit, starting with number 3, fit with historical tradition of firearm restrictions. Outside the presumptively constitutional exceptions, the validity of laws that fall under the Second Amendment's text is determined by history and tradition. In Bruin and Rahimi, the Supreme Court instructed lower courts to follow an originalist methodology in conducting this inquiry. Now we're on page 23. There is a long footnote, and it's worth looking at. If you go back up, as we show below, waiting periods are neither long-standing nor widespread practices and diverge from history and tradition. Plaintiffs would overcome any presumption of constitutionality. Here's footnote 7. Even if we found the Waiting Period Act to be presumptively lawful, we could not end our inquiry there. Because the plaintiffs also argue that the Waiting Period Act would be put to, quote, abusive ends, unquote. Yeah. Yeah. This language of abusive ends. We read Bruin's abusive ends limitation to mean that any condition or qualification on the sale or purchase of firearms, if found to have such abusive ends, negates the presumption that the law or regulation is lawful. A supposed condition or qualification that applies as broadly as this one, put toward an end that is justified only by assuming that citizens cannot be trusted with their own rights, is put toward an abusive end. I'm going to read that again. That's a really good quote. This is footnote 7, page 23. Ortega versus Grisham, 10th Circuit Court of Appeals. A supposed condition or qualification that applies as broadly as this one, put toward an end that is justified only by assuming that citizens cannot be trusted with their own rights, is put toward an abusive end. The dissent concludes otherwise only by confusing who was burdened by the law in RMGO, that's the 10th Circuit precedent they referenced from 2024, with how ordinary citizens are burdened by New Mexico's law. I'm going to reread that whole thing there. A supposed condition or qualification that applies as broadly as this one, put toward an end that is justified only by assuming that citizens cannot be trusted with their own rights, is put toward an abusive end. That language of abusive end is coming from Bruin. The dissent, in this case, Democrat, I believe, concludes otherwise only by confusing who was burdened by the 10th Circuit precedent and how ordinary citizens are burdened by New Mexico's law. What he's doing there is he's trying to affirm the 10th Circuit precedent, which is what they're supposed to do as lower court judges, and at the same time say how the dissent is wrong. Matheson is dissenting, and I believe he's an Obama judge. Okay, let me see. Who's writing this again? This is Timkovich. Yeah, Timkovich is Republican. He was for a long time the chief judge on the 10th Circuit. He was one of the guys that he was the one of the guys that guys, I should say. It might be a woman actually. I can't remember. But Timkovich was someone who spoke in defense of Gorsuch at Gorsuch's Senate Judiciary hearing when he was taking the place of Scalia. And then EID is the next guy, the next person on this. I think it's a woman, Trump appointee, I believe, who took place of Gorsuch on the 10th Circuit. So you have two Republicans, one a Bush appointee, one a Trump appointee, having the right answer on the same team here on waiting periods in the Second Amendment. So that's pretty exciting to me. I like to see that kind of agreement with Republicans, and it's no surprise that Democrat is in dissent. We're still working on convincing these Democrats that they've gone off the rails on this stuff. Okay, in doing so, we examine our historical tradition of firearm regulation to help delineate the contours of the right. If a challenge regulation fits with that tradition, it is lawful under the Second Amendment. Because these laws may infringe on constitutional rights, it is the government's burden to justify its regulation. Let me say that again. It is the government's burden to justify its regulation. See, that's different. That's the brilliance of Bruin. That's the wonderful thing about the Republicans on the Supreme Court. That's the wonderful thing about this whole tradition, which I was a part of in high school, of arguing against gun control and learning how to argue. And that is, we are not going to take it anymore when the government says it's your burden to prove that we're doing it wrong. No, the citizens don't have the burden to justify these laws. It's the government's burden. To meet this burden, the government must show a well-established and representative principle derived from the history and tradition that would inform the text's meaning. That's from Bruin at 30. Modern restrictions must be relevantly similar to historical practices in both the why and how they regulate firearms. Why and how the regulation burdens the right are central to this inquiry. That's Rahimi at 692. Therefore, whether modern and historical regulations impose a comparable burden on the right of armed self-defense and whether that burden is comparably justified are central considerations when engaging in an analogical inquiry. Such a principle may be drawn from historical analogs to the modern statute, and a historical twin is not needed. The Supreme Court does not expect us to find a dead ringer, but the state must at least present us with a ringer. That's good language. I love that. That's great. Why do we require these showing? Through them, we seek to honor the fact that the Second Amendment codified. Now listen to this. We seek to honor the fact that the Second Amendment, that is the public law, the law articulated in writing, the positive law, sometimes it's called, okay, codified a pre-existing right. Now, that language of pre-existing right, what does that mean? Well, it could mean that it's natural law without saying it's natural law. But what else could it be? I mean, the previous positive law? um, okay, well, then you can ask, well, did that codify a pre-existing right? Eventually, you're going to get back to the natural law. I think it's going to go back to these hypothetical things that you find. For example, in the Bible, you have the example of Cain and Abel in Genesis 4. Cain kills Abel, his brother. It's the first murder in human civilization, according to the Bible. Well, like Charlie Kirk, he didn't fight back. He didn't have a chance, presumably. We don't really have details about this, and and but you can think hypothetically about it. Well, what if he did have the chance to fight back? Would he have been guilty, the victim of fighting back? Presumably, if you have a right not to be murdered, you have a right to enforce that right. There might be limitations on how that works. For example, avoiding unnecessary harm to innocent third parties, for example, avoiding damaging, and that would include damage of property, that would include physical harm, injury, or death. Okay, but there's the right to self-defense right there, right? In the New Testament, Peter draws a sword when Jesus is being arrested. Jesus says, put that sword away. There's pretty strong language in the book of Matthew. Uh, he who lives by the sword dies by the sword, something like that. And but the thing is that Jesus saw that Peter was carrying a sword, presumably this whole time, and why did that never come up? Presumably, it wasn't really an issue. And hypothetically, Peter had it because of typical things you would need certain things for. For example, you need money to buy food, you need shelter to avoid like unexpected rainstorms. You need a sword to have unexpected protection that you need. And we don't have any teachings in the Bible where Jesus said that that was inappropriate in all cases and all times. And Jesus being arrested is one of those cases where it's such a unique event. It's hard to know what general lessons to draw from it. Um, and we certainly draw very limited references from that one event for all of our other laws that we have. I mean, we don't think that stealing is all of a sudden fine just because they stole from Jesus. I mean, we don't think that murder is right because they murdered Jesus and Jesus went along with it. So these are the kinds of things that pro Second Amendment Christians think through as we go through this. Now, I love this language on page 24 at the bottom. Why do we require these showings? The Second Amendment codified a pre-existing right. In other words, the right that we're talking about, self-defense right, the right to be uh, remain innocent and not be criminalized for exercising the right to self-defense, which is really what we're talking about here. Even if it's a waiting period of 7 days, you have a right to self-defense during that 7 days, right? And you have a right not to be called a criminal for exercising this right. We have a right not to be criminalized for innocent conduct. The criminalization of innocent conduct is one of the worst things. It might be the worst thing that a government can do. All tyrannies do this, whether it's authoritarian or totalitarian, if you can distinguish those two things. Let's say that you can, and maybe you're reading Jeane Kirkpatrick back in the 80s and 70s. Actually, it was way before 80s. And you come to think that these kind of bad governments, the either whether it's bad in form or bad in substance or some combination of the two, there's bad laws or there's good laws but they're not enforced appropriately, or they're enforced selectively or hypocritically, however it goes. um, they all criminalize innocent conduct. That's what they all have in common. And what I like about the Second Amendment is it plants the flag here and says no more. It's not going to happen here. It's not going to happen here. We are not relying purely on the government to police itself. Although awkwardly, we are kind of, I mean, this court is part of the government. So, but it, it, it is kind of a separation of powers thing. I mean, you're separating the powers within the structure of government. You're also separating the powers horizontally by federalism in a way, vertically. Um, you're separating the powers between the those who have a monopoly on violence, even within the organic or the fundamental law. And here you have the government itself. Now they're all Republicans on the 10th Circuit here saying that this law is not based on itself. It's not arbitrary. Every arbitrary law is based on itself, purely. It's like, okay, we came up with this and just do it. This is saying, no, there's a prior right and wrong here. That the Second Amendment doesn't take itself to invent, but takes itself to protect. And I think that's exactly right. And however you understand that, going back to the natural law, going back to the scriptures, going back to both, um, it's going to be a pre-existing right belonging to the American people one that carries the same scope today as it was understood to have when the people adopted it. Page 25. When a challenge regulation addresses a general societal problem that has persisted since the 18th century, the failure to identify a distinctively similar historical regulation addressing that problem is relevant evidence that the challenge regulation is inconsistent with the Second Amendment. That's Bruin at 26. Because the burden is on the government at this stage, we consider the historical examples provided by New Mexico and its experts. First, we reject the notion that other waiting period laws themselves carve out a historically grounded principle. They are mostly a modern innovation. New Mexico points out that the Waiting Period Act's historical pedigree stretches back to 1923. But that is an oversimplification. Where are we at? Um, that true, California imposed the first 1 day waiting period in that year, intending to give officials time to conduct a background check. See Sylvester at 824. We covered that on the Republican Professor podcast. A few states followed suit over the next few decades. But those early examples are easily distinguished from this one because they were explicitly tied to the time it took to conduct a background check. Until the 1990s, no waiting period law required a prospective buyer to wait longer than was necessary to conduct a background check. Federal law briefly required a universal waiting period during the completion of a background check from 1993 to 1998. See the Brady Handgun Violence Prevention Act of 1993. But Congress sunsetted that law from the start, and the waiting period requirement lapsed when the federal government implemented the National Instant Background Check System in 1998. See Prince versus United States. 1997 at pages 902 to 904. By the way, the guy that won Prince versus United States 1997 was a guest on the Republican Professor podcast. See Stephen P. Hallbrook's episodes. He came on multiple times. Um, and I'm what I love about uh, his daughter is his uh, assistant, has been his assistant for a long time. She posts Gary Larson cartoons every day, so she's my Gary Larson person every day. Hallbrook's daughter, Lisa. Anyway, okay. Page 26. Um, the first state waiting periods that were untethered to the time that it takes to pass a background check or complete certification course did not appear till the 1990s. Sylvester versus Harris. Oh man, we covered that on the podcast, Sylvester versus Harris. By the way, Harris, which Harris is this? Yep, that's right. Good old 2024 Kamala Harris. We dodged a bullet, guys. We dodged a bullet. Let's keep that momentum going. Even now, about a dozen states impose waiting periods of some kind. Given the few states in which they have persisted and their duration, waiting period laws cannot satisfy the government's burden. Um, any innovations of the mid to late 19th century come too late to provide insight into the meaning of the Constitution in 1787. Comparing this history with the Supreme Court's analysis of other originalist sources, waiting periods lack a strong historical pedigree. We're on page 27. Second, New Mexico contends that a variety of firearm restrictions are analogous to the Waiting Period Act, intoxication laws, license and permitting regimes, targeting group bans on firearm carry or possession. New Mexico argues that all three categories indicate that founding era governments could limit access to firearms to ensure that those keeping and bearing arms were responsible and law-abiding citizens. True, shall issue licensing regimes, background checks, and many other barriers to firearm access serve that purpose. But the only way that the Waiting Period Act fits into that principle is if anyone seeking to purchase a firearm can be presumed irresponsible or non-law abiding purely by dint of their intention to purchase a firearm. Constitutionally, they cannot. Every once in a while, you get a sentence like that that's just like, yeah, only a Republican would say that. Only a Republican could say that. Bam, just boom, right there. Republican thing right there. In Bruin, the court rejected the government's attempt to characterize New York's proper cause requirement as a sensitive place law when there is no historical basis for New York to effectively declare the island of Manhattan a sensitive place simply because it is crowded and protected generally by the New York City Police Department. Let's take a look at these footnotes. Footnote 8. New Mexico also argues that a waiting period is no less burdensome than typical delivery periods in the era before FedEx, online ordering, and modern shipping methods. That comparison is unpersuasive. Necessary or unavoidable delays in possession resulting from ordinary physical limitations and private market forces are not prohibited by the Constitution. I have LOL in my notes here. It's amazing what you have to explain to these Democrats. It's like you got to get a lobotomy to graduate from some of these law schools or something. I don't know where they get their ideas. Necessary or of unavoidable delays in possession resulting from ordinary physical limitations and private market forces are not prohibited by the Constitution. Government erected barriers to possession, resulting in artificially manufactured delays. Oh, look at this language. Are covered by the Second Amendment's text. Wow. Republican. I'm just saying. Look, I'm just saying. Even though many of these historical examples arose before the 14th Amendment's passage, this is footnote 9, and therefore before state incorporation of the Second Amendment, neither the experts nor the state's brief discuss whether these historical restrictions were similar to a similar protection under state constitutions or common law. This silence adds to our skepticism of these analogies' relevance. Wow. All right, let's keep going here. We similarly reject New Mexico's attempt to declare the entire population of New Mexico presumptively dangerous to themselves. Wow. Man, this is great prose. Let me go back to the previous sentence because I got cut off by these footnotes. I like footnotes. Don't stop doing footnotes. Don't do endnotes. Footnotes are good. In Bruin, the court rejected the government's attempt to characterize New York's proper cause requirement as a sensitive place law when there is no historical basis for New York to effectively declare, I think it would be better to say effectively to declare the island of Manhattan a sensitive place simply because it is crowded and protected generally by the New York City Police Department. Similarly, we reject New Mexico's attempt to declare the entire population of New Mexico presumptively dangerous to themselves or others only because they want to acquire firearms. Wow. That is great. I love that. In Bruin's terms, the Waiting Period Act does not impose a comparable burden on the right of armed self-defense as its supposed historical analogs. A closer examination into the three categories reveals the differences. Intoxication laws. In the years after ratification, at least 20 states criminalized firearm use or carry by drunks through various intoxication laws. And at least in 30 states, and even in 17th century England, governments regulated firearm use and carry by the inebriated. Once the drunk sobered up, he could carry or use the gun once again. This burdened the Second Amendment rights of individual would-be purchasers, but only for a short time. Let's take a look at footnote 10. Footnote 10. To say that a desire to purchase a firearm renders one dangerous or presumptively not law-abiding for a time would also penalize someone for exercising a constitutional right, which is obviously unconstitutional. Nice job. Nice job, dude. Here's footnote 11. Surety laws. Okay. Yeah. So it's basically distinguishing, saying why surety laws don't work for waiting periods. Okay. The goal of these laws was to prevent unpredictable and dangerous firearm use by the intoxicated. I mean, it makes sense to me, right? It's right there in the word. District courts have recognized the historic acceptance of intoxication laws as permissible under the Second Amendment. How intoxication laws burden the Second Amendment rights is ostensibly similar to how the Waiting Period Act works. Both burden the Second Amendment by imposing a temporary inability to acquire firearms. Intoxication laws even go further than the Waiting Period Act in the burden imposed because they reflect a founding era willingness to prohibit both firearm acquisition and use, while the Waiting Period Act is limited to acquisition. New Mexico seeks to ground the analogy in the burden's temporary nature, deriving a principle from that analogy that the Second Amendment tolerates disarming anyone in a supposed state of dangerousness. But New Mexico ignores key distinctions that shatter the analogy. The scope and underlying justifications for the burdens that are vastly different. Intoxication laws place an individualized burden on intoxicated individuals, which distinguishes those who pose a credible threat to physical safety of others from those who have not. That's Rahimi at 700. The Waiting Period Act, however, applies a blanket burden across all of society, assuming that everyone is dangerous or unstable before they can exercise their Second Amendment right. While the justification for both laws at the highest level of generality is the same, preventing gun crime by dangerous or unstable people, one need only look at one level deeper to see that who New Mexico treats as dangerous, everyone, is not comparable to who historic intoxication laws treated as dangerous, intoxicated individuals. History is consistent with common use. It demonstrates that legislatures have the power to prohibit dangerous people from possessing guns. But that power extends only to people who are dangerous. That's Cantor versus Barr, Barrett dissenting. Barrett is now on the Supreme Court, FYI. Cantor versus Barr, 7th Circuit, 2019. New Mexico makes no effort to distinguish the dangerous from the law-abiding. What could possibly go wrong with this? I mean, look at this sentence. New Mexico makes no effort to distinguish the dangerous from the law-abiding. Instead, choosing to broadly restrict arms used by the public generally. Man. In other words, individual or particularized determinations that a person or subcategory of persons represent a known danger is one thing, but blanket burdens on the public's right to keep and bear arms are another. Temporal similarity is not enough to carry the day. Let's look at footnote 12. Okay, another distinction with the 10th Circuit precedent in RMGO. Okay, good. Permitting and licensing regimes. I'm not saying I agree with that precedent, RMGO. I'm just saying I think it's good that he's trying, or that Timkovich is trying to get this through in a way that will stick. Historic licensing laws on page 31 at the top, similar to modern shall issue licensing regimes, required a person to submit some kind of information or receive some certification to acquire a gun. They typically applied universally or near universally. New Mexico's experts listed many examples of historic licensing restrictions, including concealed carry licenses, gunpowder licenses, commercial dealer licenses, and hunting licenses. These licenses limited access, much like shall issue licensing regimes restrict today. Yeah. I mean, are you guys getting this? Is this making any sense? I mean, we're not striking pennies anymore. So if it makes sense, it's going to make dollars. Because if it makes 100 cents, it makes at least $1. All right. Well, very few of these licensing restrictions applied to all guns, all people, or all places, much less all three. Right? Okay. It is this distinction in breadth, treating all those seeking a firearm as unusually dangerous, that sets the cooling off period apart from all historical permitting regimes. That's a key sentence right there. New Mexico cannot justify a populace-wide burden using only class-wide foundations. Nowhere in the historical record have universal restrictions on firearm sales survived originalist scrutiny. Wow. Whereas this waiting period, applicable to nearly all individual purchasers and untethered to a background check or satisfiable condition, is a when restriction, not a who restriction. Volokh, okay, sorry. I'm sorry. I messed that up. Whereas this waiting period, applicable to nearly all individual purchasers and untethered to a background check or satisfiable condition, is a when restriction, not a who restriction. Basically, they're saying, yeah, New Mexico screwed that one up too. And then look at Volok and I think that's the 2009 UCLA. It's the 56th volume of the UCLA Law Review at 1444. I believe that's 2009. I've read that volume. Licensing and permitting laws typically require the completion of a course, certification, background check, or training before a person can acquire a firearm. But the key to their constitutionality is that they presume a person can qualify for the license unless proven otherwise. So it's about burden of proof kind of thing. Bruin found a licensing law that required applicants to show a special need before they could exercise their rights to be out of step with the historical tradition. Likewise, assuming that all people are dangerous if they desire to exercise their rights unless special circumstances apply, is historically out of step. Very good. Very good. Group bans and restrictions. Easily the least applicable historical analog is the last category that New Mexico points to, group bans. These types of bans categorically denied access to firearms by freemen or black slaves, American Indians, and other disfavored ethnic or cultural groups. Timkovich has Native Americans instead of American Indians, but I fixed it for Timkovich because I'm a Native American, but I'm not Indian. I was born here. I'm native to Colorado. I'm a Colorado-born guy, native to Colorado. I'm a native Coloradan. That means native means where you're born, and Colorado is in the United States. It's in America, so I'm Native American by geographical deduction. No doubt, these types of laws proliferated in colonial and founding era society, whether out of misguided cultural beliefs that these groups were prone to violence or a more realistic belief that slaves might turn arms against their owners. Most of these laws were justified by concluding that those populations were dangerous. And now we're on top of page 33 at the top. Some laid a burden even heavier than the Waiting Period Act imposes, though the burden was still narrower because none was society-wide. But, as with intoxication laws, the justifying principle used to identify who qualified as dangerous differed from the law before us. Racism, classism, and other discriminatory biases motivated these targeted laws, not a general fear that all citizens could not be trusted to exercise their rights responsibly. Once again, New Mexico cannot justify a populace-wide burden using only class-based foundations. And even if these historical practices categorically denying firearm sales to ethnic or cultural groups established a helpful principle, they would not be proper comparators. Yes, he just did say that. The Democrats in New Mexico were using racist laws to justify their desire to subjugate their own citizens. Yes, they were using the Democrats. Let me just say this again. The same political party that started the Ku Klux Klan, the White Council, the Citizens League, the White Council, and various other groups in the wake of Republican success after the Civil War in taking their slaves from them, putting guns into the hands of the black people. That's what Republicans did. That was the foundation of the Republican Party. The Democrats used very similar, almost identical rationale in stripping Otis McDonald of his Second Amendment rights, his right to protect himself from crime, from tyrants, criminal tyrants. Sometimes even those tyrants are associated with the government, like the police, like they were during the Klan. That was during Obama that happened. The city of Chicago spent millions of dollars, entirely run by Democrats, to strip a black man of his right to self-defense, his right not to be murdered, that he could enforce himself without relying on the so-called racist police, when the Democrats themselves were saying the police were racist. There's a Christian book, allegedly Christian, written by a philosophy professor in Kentucky called Mike Austin, who, by all accounts, is a Christian, gets this totally wrong. He gets this totally wrong. He's got a book called God, Guns in America, which we analyzed on the Republican Professor podcast over 2 or 3 episodes last fall before the election. And he talks about these, he mentions these Second Amendment cases. He doesn't talk about the harm to the plaintiffs at all in his discussion of God, Guns in America. From a Christian perspective, you see absolutely no empathy or sympathy with the harm the Democrats did in the name of government to these plaintiffs that had suffered this kind of harm. No, and this is done in the name of God, in the name of Christianity. There are Christians out there that have taken too much of the Kool-Aid in Boulder, where he got his PhD, which is in the 10th Circuit. It's in Colorado. By the way, it's a satanic town. Totally satanic town. Somehow that got into his theology of self-defense and his constitutional theology there. And I'm just saying that if you were wondering why people ignore that, well, here you go. You have the 10th Circuit saying that the Democrats in 2025 are using racist laws to argue for their gun control. They're still using this as rationale for their argument, for their conclusion. These are their premises for their conclusion, that there should be gun control of these kinds, these types. I'm not making it up. It's right there. And you have a Republican saying, even if these historical practices, categorically denying firearms sales to ethnic or cultural groups, established a helpful principle, which the Democrats think it does, they would not be proper comparators. This is the Republican Professor podcast. Gets exhausting. The district court acknowledged that many founding-era gun regulations, including the historical analogs discussed by the court, undoubtedly are repugnant. Well, thank you for acknowledging that. But it recognized the Supreme Court has not suggested that courts may analogize only to those regulations that would be viewed as discriminatory or constitutional today. That is wrong. Page 33 at the bottom. See, scroll back up to the top paragraph of 33. The legal principle governing these examples is that certain individuals are not part of the political community in whom the right to keep and bear arms is vested, particularly those in a state of war with the political community or who would rise up against it if given the opportunity. Well, there you go. Yeah. Correct. Yeah. Well, let's take a look at page 34 at the top. Relying on these analogs would commit us to consider a law trapped in amber. Amber formed in an era when blatant racism escaped constitutional scrutiny. Well, let's keep going. He's being nice. But proper originalist interpretation requires a comparison between people enjoying the same set of rights. Comparing the Second Amendment rights of a citizen today with Second Amendment rights of a slave before emancipation, before Republican emancipation, a Democrat slave before Republican emancipation, and Republican Reconstruction tells us nothing. Just as a comparison between the voting rights of an adult today and a minor in 1800 tells us nothing. As New Mexico's own expert explained, quote, the chief problem facing African Americans in a racist American society was not a singular deprivation of gun rights, but the deprivation of all rights. Well, I would say, yeah, this is what I say to my students, though. When they're not sure about the Second Amendment, I say, well, how do you feel about slavery? Are you for it or against it? They're against it. Okay, you're on the Republican side there. Let's connect these two dots. Let me ask you a hypothetical. If the slaves had guns, would there have been slavery? Take as much time as you need. Open book, open note. The looks on their faces, their eyes go up and to the left and then to the right. And then they look at me as if for the first time. And I can add a few things to that question as I've posed it over the years. If the slaves, I'm going to add two things to that. If the slaves had access to guns and courage based on proper training for how to use them appropriately, would there have been slavery? They would need the courage to use them and the training to use them appropriately. You know, how to clean them, how to care for them, how to store them, and how to use them accurately. Would there have been slavery? Well, the answer is no, of course, and that's precisely why they were prevented from keeping and bearing arms. Precisely. And you'll notice that when people get this principle, they start to realize why all tyrants are against the right to keep and bear arms. All. In every tyranny under the sun. And it's for the same reason. It's because every tyrant thinks hypothetically and thinks first and foremost about how to shore up their own tyranny by getting rid of any possible potential hypothetical threat. It's the same thing on the Democrat plantation before Republicans emancipated. And praise the Lord for the Republican Party. Thank you, Lord, for what you've done. I know it's not perfect, but it is definitely better than what existed before. Thank you. The groups New Mexico and the district court identified. You're probably wondering what I'm reading. I'm reading, guys. I got my notes. I highly recommend you print it out and make your own notes. You know, think about it yourself. Come on, guys. Come on. You know what I mean, Vern? Is it just me? All right, I got to share my screen. Feel free to call me Sharon. We're getting close to the end here. The groups New Mexico and the district court identified did not possess the same rights in the founding era as more favored classes, an era corrected by the Republican Party in the 13th, 14th Amendments. So we cannot rely on them to inform our understanding of the rights coverage today. It would be, hold on a sec. It would be a category error. Originalists, or those analyzing text, history, and tradition, must take care to consider whether the historical practices brought to their attention actually speak to a rights scope. We're done with page 34. We're on page 35. New Mexico asks us to accept a principle so broad that it is obviously incorrect. Let me add something to that. New Mexico asks us to accept a statist principle so broad that it is obviously incorrect. And I add the word statist because I got that word from my libertarian friends. And all you libertarians are chuckling to yourself. Enjoy that. Yeah, enjoy that, libertarians. Okay. Well, we're on the same side here. Recall that the district court perceived a historical principle justifying prohibitions on sales to the general populace on the grounds that some among them would harm the public. If that principle were accepted, any regulation could be justified. That's what you call a reductio ad absurdum in the business. Correct. That's right. That's right. Any class of people could be the subject of a targeted ban, including age group, demographic, and geographical area. Any class could be denied access to firearms if the government feared that some among them would harm the public. It is hard to imagine an exception more likely to swallow the rule. That's very good. Footnote 13. What do we got? Although New Mexico has put forth evidence that waiting periods saves lives and prevent impulsive violence, the countervailing injury to Second Amendment across the entire state of New Mexico overbears that burden. For it is always in the public interest to prevent the violation of a party's constitutional rights. Okay. The district court concluded the third and fourth factors weighed against the plaintiffs, but that was only after holding that the Waiting Period Act did not implicate or burden Second Amendment rights. Funny how that works. Even though the potential to reduce impulsive gun violence might be true, Once we acknowledge that the waiting period act likely burdens Second Amendment activity, that potential is outweighed. The balance of the equities and the public interest favor injunctive relief, and the state can have no interest in keeping an unconstitutional law on the books. Well said. Bottom page 35. For this reason, the burden imposed by New Mexico's law is simply of a greater scale than historic sobriety laws and class-wide bans on possession. See Nguyen, 2025, pages 21 to 23. Easily concluding that modern law requiring a blanket wait of 30 days between firearm purchases was not relevantly similar to historical laws targeting Indians, foreigners, and the intoxicated. See, the Democrats in California made the same argument on the racist laws, right? They made the same argument in Nguyen versus Bonta, which we won in the Ninth Circuit. And that's solid precedent now in the Ninth Circuit. We covered that on the Republican Professor podcast. None of those laws imposed a burden on the entire population. They burdened narrower subsets or individuals. And many of those laws contained exceptions or conditions that would allow an otherwise disqualified person to show himself capable of safely possessing firearms. While some historic laws resulted in would-be purchasers waiting a short time before acquiring their firearms, those waits were incidental to other lawful purposes. Nothing in the record suggests that the historically understood right to keep and bear arms tolerated universal and indiscriminate burdens on purchasing or acquiring firearms with no way to enjoy the full right. This principle cannot clarify the Second Amendment scope because the principle itself contradicts the Second Amendment's existence. Sorry, I started laughing in the middle. Some of this, I just cannot believe you have to actually say it out loud. I mean, guys, it's 2020. I'm going to talk like a Democrat for right now. It's 2025. You know how Democrats are always like looking at the calendar to figure out what they should believe about morality? I mean, I don't look at a calendar to discern right and wrong. That's me. It's a category error. But they do typically. It's almost like they treat right and wrong as like fashion. You know, they have to like look through, see if anybody's wearing bell bottoms before they go, oh yeah, that's the right thing. Well, that's not how I do it. I mean, it's amazing that you have to say this stuff. It's just amazing. Wow. It's mind-blowing. They burdened narrower subsets or individuals, and many of those laws contained exceptions or conditions that would allow an otherwise disqualified person to show himself capable of safely possessing firearms. While some historic laws resulted in would-be purchasers waiting a short time before acquiring their firearms, those waits were incidental to other lawful purposes. Nothing in the record suggests that the historically understood right to keep and bear arms tolerated universal and indiscriminate burdens on purchasing or acquiring firearms with no way to enjoy the full right. This principle cannot clarify the Second Amendment scope because the principle itself contradicts the Second Amendment's existence. Yeah, it's pretty basic, this sentence right here. That you can't rely on a principle to clarify the Constitution when that principle contradicts the Constitution. No meaningful limitation could be placed on the government's power to regulate firearms, disarm the citizenry, or criminalize firearm use if we accepted every regulation that is based on a fear that someone somewhere would likely misuse a gun. Man. Damn. Tell us how you really feel. C, the scope of injunctive relief. Finally, a word regarding the scope of relief sought by the plaintiffs. The plaintiffs request both facial and as-applied injunctive relief. Because the district court did not grant any relief, it makes no findings about the proper scope of any injunction. We remand so that it may do so now. Yeah. While the parties have fully briefed the issue on appeal, the Supreme Court has since held that courts are without authority to issue remedy beyond what provides complete relief to the plaintiffs actually involved in the suit. Because the parties did not have the aid of this decision when they submitted their briefs, this decision is Trump versus Casa, 27 June 2025, U.S. Supreme Court. Parties did not have aid of this decision when they submitted their briefs. We would have to craft a remedy under the Supreme Court's new standards sua sponte. So district court should determine the proper scope of relief given our holding that the law is unconstitutional and the Supreme Court's recent decision with the aid of briefs from the parties. Conclusion, number 3. And we're on page 38. For these reasons, we reverse and remand to the district court with instructions to enter injunctive relief consistent with this opinion. That's it. And then you have the dissenting Judge Matheson, which you can read if you want. Thanks for joining me on the Republican Professor podcast. I've been your host, Dr. Lucas J. Mather. I promised we would have a reading from Psalm 85 and Streams in the Desert, so feel free to stick around for that. This is the chaplain's corner here, and we're going to go ahead and get to Psalm 85. I'm using ESV because I'm house sitting, and this is the Bible that my mentor has, Dr. Doug Guyvett, my epistemology professor and mentor for 25 years. So this is the one he uses. It's pretty good. It's not bad. I like, mixing it up a little bit as far as the translations. This is titled Revive Us Again, Psalm 85. Lord, you were favorable to your land. You restored the fortunes of Jacob. You forgave the iniquity of your people. You covered all their sin. You withdrew your wrath, all your wrath. You turned from your hot anger. Restore us again, O God of our salvation. And put away your indignation toward us. Will you be angry with us forever? Will you prolong your anger to all generations? Will you not revive us again, that your people may rejoice in you? Show us your steadfast love, O Lord, and grant us your salvation. Let me hear what God the Lord will speak. For he will speak peace to his people, to his saints, but let them not turn back to folly. Surely his salvation is near to those who fear him, that glory may dwell in our land. Steadfast love and faithfulness meet, righteousness and peace kiss each other. Faithfulness springs up from the ground, and righteousness looks down from the sky. Yes, the Lord will give what is good, and our land will yield its increase. Righteousness will go before him and make his footsteps a way. Psalm 85, ESV, English Standard Version, a moment of reflection. Streams in the Desert, January 19th. That coffee is cold. I love this cup, though. Been using this cup for almost a quarter century whenever I house sit. It's got like a lighthouse on it. Pretty nice. January 19th, Streams in the Desert, Cowman Publications, Los Feliz Station, Los Angeles, California, 1925, non-woke edition. We're on page 21. Men ought always to pray and not to faint. Luke 18:1. Go to the ant. Tamerlane used to relate to his friends an anecdote of his early life. I once, he said, was forced to take shelter from my enemies in a ruined building where I sat alone many hours. Desiring to divert my mind from my hopeless condition, I fixed my eyes on an ant that was carrying a grain of corn larger than itself up a high wall. I numbered the efforts it made to accomplish this object. The grain fell 69 times to the ground, but the insect persevered, and the 70th time it reached the top. This sight gave me courage at the moment, and I never forgot the lesson. That's from The King's Business. There's more. Page 22. Prayer which takes the fact that past prayers have not been answered as a reason for languor has already ceased to be the prayer of faith. To the prayer of faith, the fact that prayers remain unanswered is only evidence that the moment of the answer is so much nearer. From first to last, the lessons and examples of our Lord all tell us that prayer which cannot persevere and urge its plea importunately and renew itself again, and yes, there are two renews there, and gather strength from every last petition, is not the prayer that will prevail. That's William Arthur. Rubinstein, the great musician, once said, "If I omit practice one day, I notice it. If 2 days, my friends notice it. If 3 days, the public will notice it." It is the old doctrine, practice makes perfect. We must continue believing, continue praying, continue doing His will. Suppose along any line of art one should cease practicing. We know what the result will be. If we would only use the same quality of common sense in our religion that we would use in our everyday life, we should go on to perfection. The motto of David Livingstone was in these words: I determined never to stop until I had come to the end and achieved my purpose. By unfaltering persistence and faith in God, he conquered. Streams in the Desert, January 19th. The reason you're seeing natural light here is because I'm in Doug's study here, Dr. Doug Guyvet's study, and he's got a wonderful view of the backyard, the pool, the waterfall. I don't have the waterfall on right now, but in the summertime I would usually have it on. I'm gonna maybe have a cigar out there later, have a time out there of reflection and prayer. I like doing episodes out there while I'm having a cigar. In fact, the next time I might do an episode with the camera facing the waterfall. That might be kind of nice. It's been rainy, so I haven't had a chance to do it this time. All right, well, that was January 19th, Streams in the Desert and Psalm 85, and we finished Ortega versus Grisham, the majority opinion written by Republicans on the Republican Professor podcast, striking down the 7-day waiting period of New Mexico. Thanks for joining me on the Republican Professor podcast. I've been your host, Dr. Lucas J. Mather. We'll see you next time. It's 19 November 2025, years after Jesus. It's a Wednesday. Take care.